How to use experts to win your case. Not too many attorneys really know how to use experts to win their case. The key is knowing the difference between retained experts and non-retained experts. What is an expert? Let's first talk about what is an expert. Pursuant to California Evidence Code Section 720, an expert is someone with specialized knowledge, skill, experience, training, or education. It is not a very high bar to qualify as an expert. If someone has more of these categories than a regular person, then they can qualify as an expert. So when do we need experts? Under California Evidence Code Section 801, whenever any element of a case involves a subject that is sufficiently beyond common experience, the testimony of an expert witness is required to help the jury understand, because the expert has specialized knowledge. Some of those topics include accident reconstruction to describe how an incident happened, biomechanics to describe the forces at play and if they were severe enough to cause the injuries, roadway design issues, forensic issues on a computer, or if you need to look into someone's iPhone or laptop to figure out what happened, premises liability issues to show that a condition was dangerous based on building codes, OSHA compliance, product warnings, standards of care, human factors to stimuli, reactions, intoxication, medical causation issues, psychological diagnosis like anxiety, depression, any DSM-4 identifiable conditions, future medical needs, treatment, costs, permanent disability, and loss of earnings. Expert testimony is needed to establish all these categories. For example, if you need somebody to give you future medical care for your client, a vocational rehabilitation expert is needed. For a client who has missed work as a result of the incident, you will need a retained expert like an economist. Nobody just has an economist outside the context of a lawsuit. These are types of experts that are retained for the purposes of litigation. It is important at the very beginning of your case to identify what areas in the case that will need an expert. Do not wait to the end of the case. You need to be thinking about the trial from the very start. Retained versus non-retained experts. There are two different types of expert, retained experts and non-retained experts. A retained expert is an expert that makes their opinions solely within the context of a lawsuit. They are being paid money to appear in court and give an opinion. Non-retained experts give their opinions independent of a lawsuit. Non-retained experts are very powerful because they are inherently not biased. They are not forming their opinion just because of your lawsuit. They made their opinion in the regular course of their duties. The jury respects non-retained experts because they think this is an opinion that can be trusted. We must be very careful not to convert a non-retained expert into a retained expert. Once an expert is given litigation-related materials, then they become a retained expert. Do not use the same retained experts for every case. Obviously, we want to get the best experts for our clients whenever possible. But in every single case, the expert will always be asked the question, how many times have you been retained by this firm in the past? And if that answer is hundreds of times or even many times, it will reflect poorly on the case and all credibility will be destroyed. The expert will look biased to the jury. So, as a practical tip, it is good practice to switch up the retained experts that are used in each case and not always use the same retained experts. Helpful, unbiased, non-retained experts. Non-retained experts can be anyone that gives an opinion that is helpful to the case. To find these individuals who may serve as non-retained experts, it is important to review every medical record, every police record, every Occupational Safety and Health Administration OSHA report, everything there is in the case. If you come across a piece of evidence or an opinion that is helpful to your case, then it is good practice to depose that individual responsible for making that opinion and consider designating them as a non-retained expert. All the available evidence must be reviewed to determine if there is anyone who is an unbiased source who can help in the case. That helpful witness could be a mechanic who checked the car, or a building inspector who said there was a code violation, or an engineer, or a police officer, or a firefighter, or an EMT, emergency medical technician. The most common non-retained experts in a personal injury case are the treating doctors, like ambulance technicians and emergency room providers, and any doctor who is not designated as a retained expert for purposes of litigation. Also, people who reviewed surveillance video or a phone carrier representative from a service provider in which records and other evidence were subpoenaed can all be considered non-retained experts. It is very important to have a strategic game plan and determine which evidence is important to be admitted at trial. Experts rely on hearsay evidence to form opinions. We must designate witnesses as an expert for hearsay purposes. Hearsay evidence is critical when considering who may be considered an expert, both non-retained experts and retained experts. Hearsay is an out-of-court statement being used for the truth of the matter asserted. Hearsay can be if somebody writes something down or somebody says something out of court, not under oath. The controlling case law in California is the case of People v. Sanchez, which states that an expert can rely on hearsay to form their opinions, but they cannot relay that hearsay information to the jury. The rule regarding testimony and hearsay is rely, not relay. The key is that the expert can rely on case-specific hearsay evidence to form their opinions, but they cannot relate that information that they used in forming their opinions to the jury. Prior to the People v. Sanchez case, experts were sharing untested hearsay information to the jury. The hearsay information is considered untested because whoever said or wrote the information was not on the witness stand subject to cross-examination, and there was no way for the jury to determine and test the truthfulness of that evidence and to question whether or not it was accurate. There is an obvious need for experts to rely upon hearsay in forming their opinions. Particularly, experts must rely on case-specific hearsay like police reports and medical records. But what the case of Sanchez says is absolutely they can rely upon case-specific hearsay. They can review those medical records. They can review those traffic collision reports. They can review all that case information. But when they take this witness stand at trial in the court of law, the experts are not allowed to just blurt out that hearsay information to the jury. Experts can rely on the hearsay that they learned, but they cannot relay that information to the jury. The problem is that sometimes we need our experts to talk about that underlying information. We need them to get up there and say, I believe that this plaintiff suffered a traumatic brain injury based in part on the records that I read from the emergency room where he was diagnosed with a concussion. So, first introduce the foundational information at trial through non-retained experts to avoid hearsay. So how do we get around the hearsay issue? The answer is that we first present our non-retained experts' testimony at the time of trial to establish the foundation. We call the emergency room doctor. We designate him as a non-retained expert. We call him or her to the witness stand and they testify and they say, yes, I am the one who diagnosed the concussion. I believe that's what happened. Now, after calling this witness to testify, or by introducing their deposition testimony, this information is no longer considered hearsay. It is a statement that has been made in front of the jury at the time of trial, subject to cross-examination. The most practical tip in this setting is to later present the retained expert only after the non-retained expert has already testified to the jury about the foundational information and the jury has already heard the evidence. The order in which the expert witnesses are presented at trial to the jury is critical. When the retained expert takes the witness stand later, they can then repeat what was already said in open court because it is no longer considered hearsay. It is critically important when handling a case to understand where the information will be coming from and how we can get it in front of the jury at the time of trial. Some defense attorneys do not fully understand the Sanchez case, and they think that their expert will just take the stand and testify in open court to the jury about the hearsay information that the expert relied upon in forming their negative opinion to our case. That is a violation of the law established in the Sanchez case. As a plaintiff's attorney, we need a game plan to figure out what evidence we need to get in and how we will get it in front of the jury at trial. These are the questions that need to be asked. First, when it concerns the testimony of our retained experts, we must ask, why do we need the particular information to be presented to the jury? Why do we need this information? Most of the time, the answer is because it is needed to meet our burden of proof, the burden to prove our case. Whereas for non-retained experts, it's either a way to get in the critical information or it is to lay the foundation for what our retained experts will need in order to give their opinions later. Non-retained experts can lay the foundation for the evidence relied upon by the retained experts so they can give their opinions later in the trial. The subject matter of the expert opinions given by retained experts and non-retained experts have different parameters. A retained expert can cover any opinion that they have been designated to cover and have testified to during their deposition. But a non-retained expert can give any opinion that they formed during the course of their normal duties, locking in the retained expert's testimony at deposition. The opinion in the case of Kennemer versus the state of California provides that a retained expert is tied to the opinions that they gave during their deposition, but non-retained experts are not. The critical question to ask a designated retained expert at their deposition is, have you given all your opinions you intend to give at trial? And then also ask the designated expert, have you given the basis for these opinions? And then it is also very important to ask, if you have any subsequent opinions, will you let me know so that we can depose you again on those subsequent opinions before trial? As long as you have asked those critical questions at the deposition, then the retained experts are locked in and cannot give other opinions at trial. But non-retained experts are not limited in the same way as retained experts. Non-retained expert opinions at trial. In the California case of Shriver versus Kaiser, the court states that the treating physician may actually give opinions on causation and standard of care if they were formed as part of their normal duties. And another California case of Ochoa versus Dorado says that the treating physician can give an opinion outside of their direct care as long as that knowledge was acquired independent of the lawsuit. For these reasons, it may be okay to ask your non-retained experts their opinions that you think may only be for retained experts. This could include asking the non-retained experts their opinion on the reasonable value of services, even if those services were outside their direct care, only if that knowledge was acquired independent of the lawsuit. Expert materials. Retained experts should be given all possible information so that they can form their opinions. This includes all discovery, depositions, photographs, opposing opinions, and any demonstrative evidence. As a practical tip, if your expert testifies first and then the opposing expert is deposed, it is important to provide your expert with the opposing expert's deposition transcript to review so your expert can write a subsequent opinion about the opposing expert's testimony. And the defense can have the opportunity to depose your expert again on this subsequent opinion prior to trial. Regarding non-retained experts, you do not give them anything. Occasionally, medical records may be provided to a treatment provider solely for treatment purposes, not for litigation purposes. But be careful, because the case of Dozier versus Shapiro states that a non-retained expert can be retroactively converted into a retained expert if provided with litigation materials. And then the retained expert could possibly be excluded from trial altogether because they were not designated. Expert depositions. You should depose the retained expert shortly after the expert has been identified in the designation notice, whereas non-retained experts should be deposed as soon as possible to acquire the foundational information. Technically, there is no requirement to pay the non-retained experts for their time in sitting for a deposition, but it is still typical to provide them payment for their time. It is also important to know that the defense does not have the right to redepose the non-retained expert whose deposition has already been taken. Whereas, even if a retained expert has already been deposed in the litigation, they must sit for another deposition following their designation as being a retained expert. You should always videotape all deposition, no matter which side is noticing the deposition. A proper notice that you will be videotaping the procedure and that you intend to use it at trial must be served prior to the deposition. As a practical tip, at the end of the defense deposition of your retained or non-retained expert, you should always conduct a mini version of a direct examination, because if for some reason you are not able to call that witness to trial, you can always play that video of that direct examination. Moreover, you should also use your demonstrative evidence during the deposition of your retained expert, because your retained expert is considered a teacher and their testimony will only help the jury understand the evidence. Multiple experts. In many of our cases, we will have multiple expert witnesses, especially as retained experts. It is important to know that the case of People v. Sanchez applies to both sides, plaintiffs and defendants. It is really important to make sure that our retained experts have the foundation for everything for which they are testifying. So, for example, a life care planner in a major catastrophic injury case will need to rely on a lot of hearsay information from the medical records. So, before that life care planner can even come into trial and testify, we must make sure that we have gotten all that foundational information that is needed. We must depose some of the non-retained doctors so that we are giving the retained experts the required foundational information that they need to render their opinions at the time of trial. Party admissions exception to hearsay. The case of People v. Sanchez, in many cases, may work more against the plaintiff than the defendant, because in personal injury cases, we are dealing with medical records. And while it is a hearsay document, we need to know that there are hearsay exceptions. One common exception to the hearsay rule is known as the party admission. The plaintiff client is considered a party to the lawsuit, and the statements that the client provides to their doctors may fall under the party admission exception to the hearsay rule and be admitted as evidence at trial. Many times, the defense attorney will refer to the medical records and could possibly ask the plaintiff at trial, "Isn't it true that you told your doctor that you didn't feel any pain?" Additional materials outside the normal course of treatment. With regard to retained and non-retained experts, it is important to make sure you do not give the experts more information than is allowed. There is a difference of what an attorney can give to each type of expert. If you have a doctor who is a treating doctor, it is totally okay for the client to bring their x-rays and their MRIs and other materials that a doctor would normally review, even though they did not obtain the materials through the normal course of what they do as a doctor. But it would not be okay for the treating doctors to get your retained experts' reports. The non-retained experts cannot rely on the retained experts' reports. We also have to understand that generally, a non-retained doctor may not be able to comment on causation. So, if there is a causation issue in the case, like if the accident in fact caused the injury when there is a pre-existing condition, then we must have a retained doctor who can give their opinion on the issue of causation. Expert designation list. In the designation of non-retained experts, many attorneys simply may have their paralegals go through all the medical records and just write down every single provider that the client has seen. This is a huge mistake because there may be a non-retained expert or treater that we really do not want to come in and talk about the fact that the client said, hey, my pain is 0 out of 10. But if you inadvertently designate that particular treater on your non-retained expert list, and even if the defense fails to designate them in their non-retained list, the defense can still call them as a witness. So, before the plaintiff's attorney lists every single treater, we should take a critical look at who is actually going to be important for the case and only designate those important, helpful providers.